Good afternoon. I'm Senator Orrin, and I'm very happy to be with you this afternoon. Thank you. Thank you very much. Thank you. We have a very distinguished panel, as you can easily see, to participate this afternoon, all of whom are friends of mine and very outstanding individuals. I've been asked to be the moderator. I can only stay for a short time, but Brad Reynolds has agreed to sit in for me, and Brad is always a better substitute anyway. Let me just say, as a moderator, before I begin, I've had a suggestion that all of you should put the city you're from on your name tags so everybody can get better acquainted. So if you'll do that perhaps while we're doing this, we'd appreciate it. And write it larger for those of us who can't see up close. As a moderator, I envision my role in this panel as akin to that of a trial judge. I have the opportunity to introduce the case, ensure that the advocates are fair with each other, competent on the issues. I have a right to comment on the issues as well, and finally, turn the facts over to the jury, namely you, the audience, for a verdict. I must warn you, however, that if I disagree with your verdict, I may arbitrarily set it aside without any basis whatsoever. Now, we would be remiss, in my mind, if we did not acknowledge that this convention of the Federalist Society is occurring during the year that we commemorate the bicentennial of the greatest Federalist Convention. That reminds me of one tense moment in the Great Debate in 1787. It seems that on one particular day, Luther Martin, who ultimately declined to sign the Constitution, was not altogether pleased with the course of the proceedings. In a fit of pique, he exclaimed, "I'll be hanged by the people of Maryland if I agree to it." Another delegate quickly answered and said, "Then I advise you to stay in Philadelphia." For my part, I think that this aspect of the legislative history of the Constitution is binding. Any legislator or judge refusing to respect the agreements found in the Constitution ought to be hanged unless, of course, they agree to remain in Philadelphia. With no further ado, I'm going to proceed with my judicial duty. First, presentation of the issue. It seems to me that this panel has before it two major questions or issues. The first question is rather general. What is the proper role of the judiciary when a general statute does not clearly apply to the facts of a particular case? In other words, what is the latitude of the courts to infer a policy or to, quote, fill in the blanks, unquote? The second question is more specific. What is the value, if any, of legislative history in statutory interpretation? Because this may be as close as I ever get to presiding in a courtroom, I intend to depart from normal judicial procedures and address the jury before the advocates present their cases. I might say, being a judge could go to your head. On the first general question, I will venture a brief and general response. If the chefs cannot agree on a menu, arguments over whether they might have intended to prepare apple pie or apple turnovers are tasteless. In other words, if the Congress does not enact a discernible principle for the resolution of cases, then justices or judges have no law to apply. I intend to devote my time for comments to the second, more specific question. In my mind, legislative history properly applied can have great value in the interpretive process. Furthermore, text without context often invites confusion and judicial adventurism. Use of legislative history to ascertain the context of an ambiguous and disputed text apparently gained ground during the Lochner substantive due process era, when lawyers sought additional tools to hold judges to the meaning of the legislature. In this era of renewed substantive due process and freewheeling statutory interpretation, reliable forms of legislative history can serve as additional strands to tie judges to the law itself. You will note my emphasis on, quote, reliable forms, unquote, of legislative history. It is undeniable that some legislative history plays no legitimate role in the legislative process. Accordingly, attorneys and judges can manipulate the interpretive process by carefully selecting and endowing with undue weight some statements uttered in the course of the lawmaking process. Legislative history is generally accompanied, however, by clear indicia of its legitimate role in the legislative process and of the weight it ought to carry in illuminating the words of the law. A careful student of the lawmaking process should have little difficulty in establishing the weight or weightlessness of the forms of legislative history. Now, this gives new meaning to the legislative term hot air. Ironically, the increasing judicial attention to legislative history has also increased the amount of legislative history of marginal worth. As a member of the legislature, I think I understand this. On the one hand, I feel that legislative history is important, but on the other hand, I understand what I'm saying when I talk about legislative history of marginal worth. Every legislative staffer wants to write a speech or report that determines the outcome of a future case. Thus, legislative history can be abused in the creation stage as well as in the interpretation stage. The abuse of legislative history in the creation stage occurs when unelected staff members cook up some language for a committee report or a speech on the Senate floor with an eye to influencing uninitiated or outcome-oriented judges. In Congress, we joke that this kind of legislative history is everything that its author could not get into the statute itself. And in truth, this is no joke. This kind of legislative history is generally recognizable. Let me proffer an example. In 1982, the Supreme Court decided that a collective bargaining agreement may be unenforceable when a business enters into bankruptcy. That was the Bildisco decision. There was a general agreement in Congress on a compromise that would preserve the basis of the Bildisco case when necessary to protect other creditors and overrule the case when necessary to prevent the use of artificial bankruptcies to avoid a union contract. The Senate struggled for weeks in committee and on the floor to find a standard that would split this difference. At length, in a conference meeting that lasted literally until 4 a.m., and I was part of that conference, in fact, helped to draft the final compromise, we arrived at a formulation acceptable to the conferees. A few days later, this standard was adopted by both the House and the Senate of the United States. I was approached a few days later by a cadre of business leaders. They complained that another senator had introduced into the congressional record a statement that was not delivered live for obvious reasons. It was a lengthy legal brief explaining that the new standard completely overturned Bildisco, something that everybody agreed was not the case, who was really behind the bill and the change. They complained that this skewed explanation would slant the judicial construance of the compromise standard. In my view, their concern was overstated because that particular slanted legislative history was hardly part of the legislative process and was clearly recognizable as such. It was a lengthy, legalistic presentation complete with citations delivered by one member of the Senate on which no other senator had even ventured to comment. Now, this speech had never even been presented. It was dropped into the record, just simply given to the clerk with a name on it and said, "Print this as though I gave it." It was dropped into the record, and it was dropped into the record because had he given it, a number of us would have had to stand up and say, no, that is not correct. So they did it at the last minute in an attempt to influence future cases. At best, it was the view of one member and not the view of the entire Congress. At worst, it was the unreviewed opinion or work of an unelected Senate staffer, perhaps with the help, and probably with the help of a number of union very shrewd intellectuals. Now, I will be glad to let you in on an obvious secret. Statements by a single senator that are not the subject of debate are often included in the record to satisfy a constituent who was not happy with the outcome of the debate, the law, the legislation, or the Supreme Court case itself. Unfortunately, a judge could potentially seize upon that unreliable comment in the congressional record to lend credence to a preconceived result. For example, the chief sponsor of the 1964 Civil Rights Act, Hubert Humphrey, repeatedly reassured his colleagues in debate that the new law would not result in forced busing. He even worked to incorporate into the civil rights law two provisions guaranteeing that students would not be transported, quote, from one school to another in order to achieve racial balance, unquote. As you know, neither the text of the law nor its legislative context prevented judicial busing orders. Admittedly, legislative history can be manipulated, so by the way, can the words of many laws and of the Constitution itself. This does not, however, argue for the rejection of legislative history any more than for rejection of any rule of law. By the way, committee reports often fall in the unreliable category, unless they are referred to or quoted in debate or otherwise the subject of some direct consideration. You can often assume that they were not read by, let alone written by, elected officials. Accordingly, they are often only legislative history, only tangentially related to the actual legislative process. Now, we all know that legislative history, like the law itself, can be misused, but it can also provide reliable context for the text of the law. If both houses of Congress defeated resoundingly an amendment that espoused the position urged by an overzealous litigant, for instance, we would probably consider that rejection good evidence that Congress did not mean to take that particular course. Let me give you a recent example of this. During consideration of the 1984 Comprehensive Crime Control Act, something, again, I was intimately familiar with, Senator Mitchell offered an amendment to limit pretrial detention of dangerous suspects to an absolute 60 days. The amendment was defeated because, as I argued on the floor, the Speedy Trial Act already contains a strict policy against lengthy detention pending trial. The Senate clearly voted to include a durational limit on pretrial detention in the new bail law. Nonetheless, a New York district court ordered the release of one of the organized crime bosses, Mr. Colombo, rounded up by Rudy Giuliani, because the complicated nature of the case could result in lengthy detention. Fortunately, the Second Circuit Court of Appeals reversed the release order after reviewing the legislative history of the Mitchell Amendment and the Speedy Trial Act. In the Second Circuit, the legislative history was important to show that Congress had considered and incorporated the Speedy Trial Act policies into the new bail law. Now, Mr. Justice Scalia can, of course, always ignore legislative history because he always makes the right decision anyway. But we worry about other judges, I might add. Another example might serve to show the kind of legislative history that does provide context for the text of the law. When the Balanced Budget Amendment was considered by the Senate 2 years ago, and I apologize for using these issues in which I was intimately associated, but when it was brought up, the Senate grappled with the concept of what type of expenditures would be, quote, off budget, unquote, a very unique concept. The focus of the lengthy debate was the language of the committee report. Senator Heflin from Alabama insisted with considerable support that a section of the report, he never mentioned this on the floor, really related to TVA, the Tennessee Valley Authority, had to be redrafted. After heated debate and the introduction of several amendments, the Senate adjourned for the consideration of the report language. Now, I worked through the night with Senator Heflin and several others on the project. 2 days later, the language was inserted into the congressional record, and the Senate recessed again to permit each senator to review that document. The following day, after more changes, the Senate came back into session to acknowledge agreement on the new draft. It was endorsed by a bipartisan majority of the Senate, including every member of the Committee of Expertise, as well as the chairman and ranking members of 3 other committees, Budget, Finance, and Appropriations. No one objected to the adoption of this understanding. In other words, the words of the document had received attention, and I might add more attention, than 90% of the bills passed by Congress. Now, this document clearly represented the best clarifying context possible on the meaning of the general words included in the Balanced Budget Amendment. I notice that a panel on tomorrow's program will discuss the open-ended clauses of the Constitution. In that connection, the history of the Equal Protection Clause of the 14th Amendment and other very broad clauses of the Constitution often provide the only restraint upon an expansive and inaccurate interpretation of what those clauses were originally drafted to accomplish. In the absence of its legislative history, few would doubt that the Equal Protection Clause could be used as a constitutional tool to effect a massive egalitarian leveling. Now, this brings us to the ultimate argument of those who might prefer the English rule, which disregards legislative history altogether, namely that if Congress intends a result, it should put its meaning into the statute. Now, this overlooks the delicate dance of the legislative process. Congress is continually weaving a course between specificity and generality. A statute must be specific enough to provide notice of what behavior is forbidden, yet general enough to prevent every attorney, including those representing wrongdoers, from finding some reason why his client falls outside of the specific definitions. Authoritative legislative history can serve to focus the general words of a statute to the specific harms it is meant to correct. Now, I do not suppose that I will surprise anyone if I note that Congress sometimes makes mistakes. I suppose the surprise would be if Congress sometimes does something right. Legislative history can also serve to overcome some congressional shortcomings. For instance, we should probably have specifically incorporated a reference to the Speedy Trial Act in the new bail law. Actually, you might as well blame the Justice Department for that. Everybody else blames the Justice Department these days. In any event, the legislative history imparted the additional information necessary to preserve the basic goal of pretrial detention. It is also probably not a surprise that Congress often does not know how to resolve a problem until it is engaged in a lengthy debate. Once again, I suppose the surprise would be that Congress even knows how to solve rather than create a problem. In instances where Congress seeks a solution during floor debate, the process becomes nearly synonymous with the meaning of the statute. The meaning of the law can often be conclusively established only by careful study of the process which produced the language. In my balanced amendment example, the Congress did not probably know what the term outlays meant until it labored to draft an explanatory document covering guaranteed loans, public corporations, etc., etc. Now, one further point with regard to legislative history. It can serve to prevent slippage away from agreements reached in Congress. It is no longer a rare phenomenon to have the senators who formed a compromise filing a brief years after the fact to explain what that compromise meant. I'm even aware of one occasion where the brief was not entirely consistent with what was said by the senator during the congressional debates. Now, a fair reading of legislative history can prevent this form of slippage away from a congressional compromise from unduly influencing the judicial process. And that particular example happened to be the Voting Rights Act. Because in that act there was a very carefully crafted compromise that later the senator who got credit for crafting the compromise filed a brief completely disregarding what he said at the time, and of course the Supreme Court followed the more expansive view. For my contribution on this distinguished panel, I would like to discuss some of the indicia that a statement found in the congressional record warrants treatment as a reliable expositor of the meaning of the law and of the text of the law. Each of the following, it seems to me, add credibility to that statement. An actual vote supporting the statement. I think that has to be taken into consideration. Substantial agreement amongst proponents and opponents of a bill as to the veracity of a statement, or the statement. In general terms, whenever Senators Metzenbaum and Thurmond agree, the statement probably has the support of the rest of the body as well. Extensive debate about the substance of the statement tends to show that it has been considered by most of the body. It doesn't fully show that, but it tends to show that. Testing of the statement by a questioning process which reveals its bounds further indicates the consideration given to the proposition. I might add that sometimes that process consists of colloquies between senators. Many times those colloquies are just put in the record, but they are agreed upon, and they generally are agreed upon by principals, and when they are principals in the debate, consideration and care has to be given to those colloquies. Concurrence in the statement by both members of the Committee of Expertise and members outside the committee. The committee system is a two-edged sword. It both cultivates an expertise and a tunnel vision. Farmers on the Agriculture Committee, for instance, should be both respected for their expertise and also considered as being out front of the rest of the body on farm issues. Therefore, a statement is most reliable as an expression of the entire body if joined by a broad cross-section of members as well as the key committee leaders. A related point. The statements of an author of a bill should be viewed like statements from the committee of expertise. It is both more informed and more likely to be out in front of the rest of the body. And an obvious point is that the number of members agreeing with a statement bolsters its acceptance as the view of the body. And when it's really tight, you might want to give some consideration either way. It is probably, and perhaps obvious, that the inverse of these conditions, a statement by a single senator that is never debated, or a member of the House, I don't mean to ignore the House, but a statement by a single senator that is never debated, the subject of a vote, or scrutinized by a debate or questioning process can hardly be said to represent the views of the entire body. Now, this discussion of the value of legislative history to enlighten the meaning of the words of the law brings me back to a statement on the first general question before this panel. Judges are confronted every day with complex disputes. They must find within the law the principle enacted by Congress which governs the statute and the dispute. This is not to say that Congress has anticipated every detail of every issue that might arise under a particular statute. Far from it. I can guarantee you that Congress is blissfully ignorant of many cases its standards will resolve. This is appropriate in our system of separated powers. It is the role of the judiciary to discern the standard promulgated by law and to apply it to the specific case. If there is no standard of law, the judges have nothing to apply. So a careful use of reliable legislative history can often, however, supply the context that enlightens the text of the law. So those are my opening remarks. I appreciate having the opportunity to express them to you, and I appreciate being with you. Thank you so much. As one of the people who strongly supports this organization and what it can mean and does mean to America, I'm really impressed to have this large audience here to hear this distinguished panel today. A few months ago, Justice Scalia was confirmed as President Reagan's second nominee, or actually second nominee to the Supreme Court. It was accomplished by a unanimous vote in the Senate. I just wanted to tell Justice Scalia how close he came to having one vote against him. When I saw Howard Metzenbaum and Ted Kennedy voting for him, I wondered what they knew that I did not. It took great effort on my part to join with Senators Metzenbaum and Kennedy to make the approval unanimously. Now, seriously, I might also add, Mr. Justice Scalia, being the first Italian to be on the court was very much in your favor. And I can guarantee you that was very helpful, and especially when Mario Cuomo stood up and said, "I will personally kill any Democrat politically." That was the only statement I've ever found of Mario Cuomo's that was accurate. I was really... Seriously, Chief Justice Rehnquist was criticized in the Senate mostly for things that happened 30 years ago. If Justice Scalia had been a little older, he might have had problems too. Now, it is my distinct honor to introduce a man I have a great deal of admiration and respect for, Justice Scalia, who I consider to be one of the brightest and most effective legal minds in America. Justice Scalia.
Thank you, Senator Hatch. The admiration is reciprocated. I found out about Mario Cuomo's remarks, by the way, when I went in to interview Senator Metzenbaum for my courtesy call. And he told me, He said, have you heard what Mario Cuomo said? I said, no, what Mario Cuomo said? Mario Cuomo said that, any Democrat that votes against Scalia is going to have to account to him. And I said, gee, Senator, I didn't tell him to say that. I really didn't particularly think that helped my candidacy at the moment, but I don't think it hurt Mario Cuomo. It is the secret of my popularity that I like to tell people what they do not particularly want to hear. The first time I addressed a Federalist Society convention 4 or 5 years ago, I observed that what distinguished the original Federalists was not that they believed in states' rights, but that they believed in the desirability of a strong and capable federal government. And I suggested that innate categorical antagonism to federal law does not make much sense. My views on statutory construction may similarly contravene what is the perceived conservative and hence the perceived Federalist Society view on such matters, because my views allow a role for judges that is, seemingly at least, more, dare I use the word, activist. It seems to me that you cannot discuss the use of legislative history in statutory interpretation unless you first decide what the goal of the enterprise of statutory interpretation is. And it seems to me that the current state of jurisprudence concerning that goal is quite schizophrenic. There are two basic models, I think, and we appear to be operating within neither of them. The first model is what might be termed the reasonable import model. If you hearken back to your first-year contract class, you will recognize it as the model applied to interpreting a contract offer. Regardless of what the offeror intended, what would the words convey to a reasonable person? The second model might be termed the subjective intent model. And again, to draw upon a contract analogy, it's the model generally applied to determine the meaning of a concluded agreement. Even if the words reasonably convey X, if both of the parties to the agreement in fact intend them to mean Y, Y it is. There's some disagreement, to be sure, over what sort of evidence can be introduced to demonstrate what the parties subjectively intended. All courts would allow course of the dealing between the parties to be introduced, and the more old fogyish courts would not allow pre-contract negotiations to be introduced, at least where the words of the agreement are not ambiguous, whatever that means. But there is general agreement in contract law that the object of the enterprise is to interpret the contract to mean what the parties intended it to mean, even though this might go against all ordinary meaning of the English language. Now, most modern expressions of the theory of statutory construction seem to embrace the latter, the subjective intent model. The supreme object of interpretation, we are told, is to discern the legislative intent. And thus, legislative history is regarded as extremely helpful in the enterprise. On closer observation, however, it becomes clear that the reasonable import model is somehow confusingly introduced into the mix. I give you two examples. It is frequently said, and almost as frequently acted upon, that legislative history cannot be used to contradict the plain meaning of a statute. But why should that be? If, as is undoubtedly the case, we accept the accuracy of legislative history in reflecting subjective legislative intent, and if we also regard subjective legislative intent as controlling, why should it be that plain language must control? It certainly wouldn't be the case in interpreting a concluded contract. Or as a second example, why should it be that two overlapping statutes are construed, if possible, and this is standard statutory construction, to give each of the statutes some effect? It's a basic principle that you try never to construe them so that one has a meaning and the other one has absolutely no remaining function. This often requires narrowing what would otherwise be the judicially determined meaning of one statute in order to make room for application of the other. But unless, as is rarely the case, the legislature enacting the later statute actually had in mind the earlier one, as I say, that's rarely the case, then that earlier statute could not possibly have affected its legislative intent. And we should interpret the later statute the same way, regardless of its effect upon the earlier one. It is clear, is it not, that this rule is a manifestation of the reasonable import model. Given the existence out there in the corpus juris, not only of the later statute, but also of the earlier one, what is the reasonable import of this body of law taken as a whole? It's fair to inquire, I suppose, which of the two models is theoretically more appropriate for statutory construction. In the contract context, of course, the subjective intent model applied only to the intent of both parties. If I can prove that I believe the contract language whose reasonable import is X was in fact intended by me to mean Y, that won't do me any good at all unless I can show that it was also the other party's subjective intent to have that language mean Y. You don't override the meaning of it except by showing that both parties intended it to mean something else. Well, who's the other party to legislation? Or is not legislation more of a unilateral act, like a contract offer, for which, as I have noted earlier, we ordinarily disregard subjective intent and we ask, what is the import upon the people to whom it's addressed? Would it not be somewhat disturbing to endorse the principle that a statute means, never mind its plain language, precisely whatever the legislature intended it to mean? I don't think it was the Queen of Hearts in Alice in Wonderland that said that. I guess it was the Cheshire Cat, but it could as well have been the Queen of Hearts. Who was it?
Humpty Dumpty.
It was Humpty Dumpty. God help me.
We've had enough of your irreverent comments here.
I'm at a loss without a law clerk. In addition to theoretical appropriateness, it is reasonable to inquire which of the two basic approaches is more practically achievable. With regard to the reasonable import approach, the objective approach, practicality depends, I suppose, on how much you believe language ordinarily has a genuinely discernible meaning. Very often, undoubtedly, several meanings may be plausible, and which is the most reasonable must depend to some extent on the judge's perception of what substantive result is absurd. Hence, the feeling that this approach gives judges freer rein. As for the subjective intent approach, its practicality depends on how much you believe a legislative intent ordinarily exists, which in turn depends on what you mean by a legislative intent. Will the view of a drafting committee alone suffice, even though there is no reason to believe that either house shared that view? And its practicality also depends on how reliable you think the indicia of legislative intent happen to be. I have little doubt that the schizophrenia regarding statutory construction which currently exists will endure. In law, as in life, complete logic and consistency rarely prevails. I do believe, however, that the balance between the two approaches may be shifting, and that the reasonable import approach, which has been receding since at least the 1920s, may be due for a modest resurgence. The reason has more to do with the practicalities I just mentioned than with the theory. Almost inevitably, as reliance upon legislative intent has increased, the reliability of indicia of legislative intent has decreased, as the various actors in the legislative process seek to skew the legislative history in one direction or in the other. Another practical development which I think may cause the shift in the balance between the two theories is what you might call legislative history overload. Once upon a time, it was quite comforting and simple for a judge, instead of beating his head against the wall to figure out what the most reasonable meaning is, to consult the legislative history and find an answer. Now he is likely to find 8 answers. And I think it is inevitable that as the process of using legislative history becomes more and more cumbersome, as the answers it yields are less and less certain, the attractiveness of the approach decreases. But to come back to the point I suggested at the beginning of my remarks, if there is a shift towards the objective, reasonable import approach, it is perceived at least that this will make room for a more active judicial role. As Senator Hatch correctly noted, the great emphasis on legislative history begins in the Lochner era, as legal thinkers were trying to get some mechanism to control what they regarded as runaway judicial activists, who would use canons of construction. As you know, they can mean anything. You pick the right canon and you get the right result. The answer to that was tie the judges down to legislative history. Well, if that was ever the result, tying them down, it's not at all clear that that's the result anymore. You may think that you're restraining activism by using legislative history, but that's not necessarily so. For example, if a judge is constrained by a plain meaning approach, there are at least some statutes that have a plain meaning. There's the answer. But if you always allow the use of legislative history, if the judge happens to like the plain meaning, he will say, where the meaning is clear, we look no further. But if he doesn't like the plain meaning, he looks to the legislative history and says, well, the meaning isn't really that plain, and there you are. So you can manipulate legislative history as well as you can manipulate the canons of construction, so that in point of fact, all that may have been achieved is simply increasing the scope for judicial discretion. On the other hand, it's not crystal clear that the objective approach increases judicial discretion. It does not necessarily have to do so. For example, the effect of using a committee report is to freeze the meaning of a statute, so that it means for all time whatever that committee said it means. If you disregard the committee report, you don't necessarily confer the discretion upon the judge. If you follow what the Supreme Court said in the Chevron case, in most federal cases, you would be conferring, I'm dead here, you would be conferring the discretion upon the agency. Where the statute is reasonably interpreted either way, the federal court, which is ordinarily interpreting a statute implemented by an agency, will follow the agency's view of the meaning. And what will the agency follow? The committee report, at least at the beginning. But what will happen is, when the committee changes, the agency may well change its interpretation to follow whatever is the desired approach of the new committee. My point is, it doesn't necessarily give greater leeway to judges. It depends on how you structure the rest of the system. I think the burden of my remarks, if it isn't patently clear by now, is that there's no answer to the question, that it would be nice to have a clear theoretical answer, and a clear theoretical approach would either allow all legislative history or throw it all out. I doubt very much whether the courts are going to go either way. I think that in the future they are likely to tend more towards more objective analysis of statutes and somewhat less towards the use of legislative history. Thank you.
Well, thank you, Mr. Justice Scalia. I would hope that your interpretation expressed here will be the only slippage to judicial activism you will ever allow. I thought I would introduce Judge Easterbrook with a question. A few months ago at a Federalist Society luncheon, Tony Podesta, the head of People for the American Way, was the speaker. Now, Mr. Podesta stressed that he could support a qualified conservative judge for the Supreme Court. One of the Federalists in attendance quickly asked him to name 3 conservative judges he considered, quote, qualified, unquote. Mr. Podesta named Judges Bork, Scalia, and Easterbrook. My question is quite simple, Judge Easterbrook. What have you done to get a qualified rating from Mr. Podesta? I have to leave after introducing Judge Easterbrook to get back to Capitol Hill, and I apologize to my friends Larry Tribe and Larry Silberman. But I would ask you to send your statements to me. I'm very much interested in this area. But at this particular point, once again, I am delighted to introduce one of the shining lights amongst our circuit court judges, Judge Frank Easterbrook. Judge.
I suppose my answer to that question has to be my knowledge of Lewis Carroll's Through the Looking Glass. I might also point out that not all of us have had to go the same way as my new colleague, Daniel Mannion. Like Justice Scalia, I also got an affirmative vote from Senator Metzenbaum, and one can take that as one will. I'm also hopeful, by the way, that in the future the Supreme Court will accept corrections so readily from judges of the lower courts, perhaps on more serious subjects.
Don't bet on it.
Don't bet on it, well. What with a small salary increase, I wouldn't be a betting man anyway. I think it's funny in a way that the Federalists should have a panel on statutory construction. It's not ordinarily a subject dealing with federalism. It's not even one on which you can have a distinctly liberal or conservative way of thought. For the Constitution, there is a raging debate. There are originalists who look to history and intent. There are structuralists who look to the problems at hand and the relation among clauses of the document. There are non-originalists who look to the values implicit in the document and say that whatever achieves more of those values is an appropriate source of judicial authority. Finally, there are those who would want to treat the Constitution as an authorization to hold a seminar in practical philosophy. For statutes, however, there seems to be no similar debate. The Supreme Court reels off unanimous opinion after unanimous opinion, all containing a formula that sounds something like this. First, look to the language of the statute. If that is clear, then stop. If it's not clear, then turn to the legislative history. If the legislative history is not clear, then do whatever the agency says. And if none of the above is clear, or if there is no agency, an increasingly infrequent event, then either go with the values underlying the legislation or put a hypothetical question. Ask what the legislature that passed this bill would have done had the issue been put before it explicitly. This rump legislature, sitting in the mind of the court, then gives an authoritative answer, and the judges are its oracles. And almost no one dissents from the method, even though there are many debates about the application of that method to a particular question. Now, if you think about the method, you realize that it incorporates what Justice Scalia called the subjective approach, one that is based squarely on original intent, using the word intent to refer to the subjective beliefs about the drafters. The assumption underlying this approach is that first, whatever Congress says goes, and second, that if it didn't say something, whatever Congress thinks goes. Now, most of the time, there's enough shared agreement about the meaning of words that whatever Congress said goes. But those turn out not to be interesting cases. It costs a lot of money to litigate, and very few cases are litigated when the clear meaning of words is itself enough to answer the question. What ends up in court are the set of questions about which one will turn past the first part of that test, turn to things like subjective intent. And in the ordinary method, we take the drafters, we find out who they were, we put the question to their subjective intent and answer it. The original intent controls, if only we can find it. I want to cast doubt on that accepted model. I want to suggest some reasons for moving more in Justice Scalia's first direction, that of objective meaning, the meaning one would give to a document received, rather than private meanings held among those who wrote it. Now, obviously, one way to do that is by debunking legislative intent. One can say there are all sorts of obscurities, that it's written by the staff, that no one reads it, that those who read it don't understand it, and so on. That's one way of doing it, but not the way I would like to pursue today. I have a different concern. The concern is the assumption that original intent matters. It assumes, in other words, that we are not engaged in an exercise in which the written word is addressed to outside readers. It assumes that we are engaged in an exercise about discerning the private meaning of language, something in which two people can share a private joke by standing up and saying, "Oh yes, number 56," that people outside are supposed to deduce the meaning of that private language. It assumes, in other words, that the written word is simply an imperfect reflection of the real law. The true law, the governing rule, isn't down on paper at all. It is in the mind of the legislators. That true rule applies no matter what the words say. And if the statute is just evidence of the true rule, the debate must go on no matter what the words. Now, the principle that the written word is just evidence of the law, of the agreement, of the underlying understanding or intent, rather than being the law, is novel. It snuck into American legal discourse almost without being noticed. Holmes could say in the 1920s that we ask not what the legislature means, but what the statute means. And when he said that, he was denying that original intent, as opposed to an objective meaning, was what governed. Now, the original meaning comes from words and structure, perhaps from identifying what the law was all about, but obviously what particular members of Congress thought the words would do are irrelevant. We care not about mental processes, but about shared meanings, about how outsiders would see it. I offer two cases for your examination. One is United States against Locke, and the other is California Federal Savings and Loan Association against Garrow. Both of them decided by the Supreme Court in the last 2 years. both of them written by the same justice, so that what I am about to discuss is not the accident of different justices with different ways of looking at statutes. The question in Locke was whether claims to federal land could be valid if filed on December 31st, when the statute said that all claims must be filed, quote, prior to December 31st, close quote. The question in Garrow was whether an employer may comply with a statute that requires women affected by pregnancy to, quote, be treated the same for all employment-related purposes, close quote, as employees not affected. The interpretive problem in Locke was whether Congress possibly could have intended to injure claimants who thought that prior to December 31st means before the end of the year. Anybody thought that those two were the same was in for a shock. The court found the language clear and stopped. Prior to December 31st means, quite obviously, on or before December 30th. All lines are arbitrary. We have no reason for thinking that one day is better than another day. End of case. The dissenting opinion thought this simply loony. There was no evidence that Congress intended to sandbag claimants, that it intended to grab back that portion of the federal lands that had been previously occupied by people who couldn't see the difference. Indeed, even a cursory review of the debates left the impression that some members of Congress also had thought that, quote, prior to December 31st was equivalent to the end of the year. So the dissent puts a hypothetical question. Is there any reason to believe that Congress wanted to set a trap for careless readers? Answering no on the basis of intent, the dissent would have changed the numeral in the statute. Then there's Garrow. The phrase, quote, treated the same, close quote, in the statute, one would think seems equally clear. It calls for identical treatment of pregnant and other employees. This time, however, the majority, written by the same justice, turns straight to intent. It observes quite accurately that the statute had been passed for the benefit of pregnant employees. It had been passed to overturn a case in which the Supreme Court had said that it was okay to discriminate against pregnant employees. And then the majority, this time, put the hypothetical question of intent. Would the sponsors of this legislation have objected to preferential treatment of pregnant employees? It answered no to this question, and that concluded the case. Now, notice what's going on. The use of original intent, rather than an objective inquiry into meaning, permits a series of highly discretionary moves. Each move greatly increases the power of the judiciary to affect, or if necessary, change the meaning of the statute. First, the court may choose when to declare the language of the statute ambiguous. There's no metric for clarity. The court's answer, in turn, often will depend on the decision whether to call something ambiguous and move past the surface, which means really that the answer is up for grabs, because the question whether to move past the surface is not itself justified in terms of any theory of meaning or even any theory of intent. Second, the court may choose the hypothetical question to be put to the legislature. In Garrow, it chose to ask the question, would you object if women gained a little more? And since it put this belated question to the sponsors of the bill, the answer was no. But suppose it had put the question, as a general matter, should the words, quote, be treated the same as, close quote, be construed to allow differential treatment? It certainly would have gotten a different answer, even from the sponsors. And of course, you have similar power of manipulation in the choice of the question, even if you put the question to a written committee report rather than to the minds of the sponsors. The choice of the question determines which answers to be found in the committee report are the important ones. The power of the question to influence the answer is well known in opinion polling. The technique is even more powerful when the judge will invent the answer as well as the question. Third, notice the flexibility in who is the addressee of the question. The majority in Garrow and the dissent in Locke asked either the sponsors or the staff, that is, the authors of the committee reports. No one asked any questions of those who disapproved of the legislation, and more to the point, no one asked that vast group of legislators who were silent on any particular bill until they cast their vote. If one is going to ask a question like this, it would be better to pop the question to the median legislator, the one whose vote could change the outcome. Suppose you would put the court's question in Garrow to a swing legislator. Then the prospect of a bill that favored one sex might lead that legislator to change his vote. If you put the question only to the fervent sponsors, the answer is not necessarily going to be useful. Now, of course, you could avoid this problem by asking still a further question. If the meaning, the question goes, if the meaning the court gives to the law today had been spelled out together with its implications, would this bill have passed? The answer often will be no. But the fact that that answer often would be no should reveal the problems in the technique of putting hypothetical questions to a body whose original intent you are grilling. It produces laws that couldn't be passed. And equally bad, I would think, the fear of Congress that their words may be used to send back answers that, if articulated plainly, could never have been adopted, will induce them to vote no in the first place. Members will vote no for fear that what they have done will be turned on its head. Now, to ring one more change on this theme, it seems to me the original intent approach ignores the fact that laws are born of compromise, that different designs pull in different directions. To use an algebraic metaphor, law is like a vector. It has length as well as direction. And one must find not simply in which direction Congress was pointed, but exactly how far it went and where it stopped. And that the problem of asking questions about hypothetical intent is much better at revealing direction than at revealing stopping places. Fourth, I think there's a question of legitimacy here. As I've said, the technique assumes that intent is the real law. Why should it be? Suppose we took an opinion poll of Congress today on a raft of issues, and we found out its views, some of them unanimous views, some of them by a bare majority. Would those views be law? Certainly not. The process of translating raw views into law is a very complex one. And what the original Federalists thought they were doing in the Constitution was creating a method by which the process tempered the result. All proposals have to run the gamut of process, the real essence of legislation. That means committees, it means fighting for time on the floor, it means compromise because other members of Congress want to hang some completely unrelated objective on your bill. It means getting it passed, it means exposing it to the veto, and so on. In Chadha, the one-house veto case, the court emphasized the importance of process. That was the original meaning behind how legislatures are to act. And yet the whole business about interpolating original intent is a form of end run around process. It's a translation straight from intent or will into law without the benefit of the testing of that will against the demands of process. Imagine the result. Suppose Congress tomorrow morning passed a law which the President signed, which said, from now on out, any result of an opinion poll taken among Congress shall be law. I should suppose we would all think that that violated some of the first principles of our society embedded in the Constitution. It's not clear to me why it should be different if all that is going on is that a very vague bill is passed and then this question of intent is put retrospectively by judges. Fifth, and my last point, the whole method of inquiry from subjective intent, I think, serves to obfuscate certain kinds of laws. Often Congress wants a real rule, that is, an absolutely mechanical device. Now, of course, tax law is full of these things, but many other parts of the law are as well. Any mechanical rule overshoots and undershoots. But often the costs of overshooting and undershooting are less than the combined costs of vagueness and the risk that the court will set off in the direction it sees Congress is pointed without realizing where the stopping point comes. Garrow may be such a case, but a method of construction that looks to intent makes real rules impossible. It excludes by hypothesis the category of laws that is rule-based rather than standard-based, because it's always possible to turn a rule into a vague standard by looking through it to intent. Intent will be less clear because less focused. Ultimately, then, I think the method of interpretation from original intent denies to Congress the possibility of legislating fixed rules. Now, you're entitled to ask, what would I replace intent with? Well, I'm not going to answer that question. But my direction, if not necessarily my stopping point, lies along the path of Holmes. It is really the path of Justice Scalia's first approach to construction. One should look at statutory structure and hear the words as they would be heard in the mind of a skilled, reasonable user of words at the time. The interpretation of statutes is very similar to the interpretation of contractual offers, one about reasonable men. And I think one should address this task without a presumption that every statute holds an answer to every question. If only we could find it. The novelty of a question, the fact that something is coming up for the first time some years after the statute was passed, may suggest that the best answer is that there was no answer. To claim to find an answer in the statute by interpretation, that is, to attribute an answer to Congress, is to claim a form of judicial power while blaming Congress. It seems to me that an appropriately modest judicial role would depend less on imputed intent, an intent that ultimately rests only in the mind of the judge, and more on willingness to put the statute down and turn, if anywhere, to the mechanisms of the common law. But the working out of that is something for another day, and perhaps one on which the appropriate deference is for me to say, I'll do whatever he tells me to. Thank you.
Energized the discussion and have made us all go away thinking more seriously about all the things that we like to talk about and debate. Professor Tribe.
Thank you very much, Brad. I'm delighted and honored to share this podium with Justice Scalia and Judges Easterbrook and Silberman. And as it turns out, I share many of the premises that you've already heard. That is, it seems to me plain, if from nothing else than the structure of Article 1 of the Constitution, that the search must be for the reasonable import of the meaning of the text that Congress enacted, not for the subjective, unenacted intent, however well we might ascertain it, either of those who made the offer in Justice Scalia's model. Perhaps we should think of the offerors as the lobbyists for the measure, perhaps even those who voted for it, or of those who finally authored the acceptance, perhaps those who voted for it, or perhaps the president in signing it. It seems to me we are on a hunt for the reasonable import of the meaning of the text. And what I want to address is the spirit in which courts should conduct that hunt. In particular, I want to propose 3 axioms, some of which may seem relatively uncontroversial until one gets to particulars. Axiom 1 is language first. Now, Judge Easterbrook says that those aren't really the interesting cases. The interesting cases are those in which the language is at least arguably unclear. But to illustrate just why I think that those cases are more interesting than Judge Easterbrook does, let me focus on the very case that he chose to discuss with you in some detail, Cal Federal versus Garrow. Now, that case is one in which it seems to me that 8 members of the court, and here I speak with all due respect, 8 members of the court failed to heed the axiom, language first. Case involved, as you already know, the Pregnancy Discrimination Act of 1978. The language which Judge Easterbrook quoted was quite clear. Women affected by pregnancy shall be treated the same for all employment-related purposes as other persons not so affected, but similar in their ability or inability to work. That language was clear. But that was not the only language at issue in the case, and indeed that wasn't the very issue. The issue was, did that act and that language preempt a California law requiring employers to give leave and reinstatement to employees disabled by pregnancy? The issue was a preemption issue. Now, Justices Marshall, Brennan, Blackmun, O'Connor, and Stevens looked at what they thought was the intent of Congress, and they said, no, there is no preemption, essentially because Congress only meant to rule out discrimination against pregnancy. And as I think Judge Easterbrook elegantly demonstrated, the question was loaded, the answer was planted, and the majority's predilections clear. Dissenting Justice White, joined by Chief Justice Rehnquist and Justice O'Connor, pursued likewise, that is Justice Powell, pursued likewise the ephemeral and I think constitutionally irrelevant will-o'-the-wisp of subjective intent, and thought it otherwise. And indeed, they added that they thought the language was clear. It said, women shall be treated the same. One justice, you might guess who he was, Justice Scalia, seems to me at least to have gotten it right by actually reading what I think was the relevant language of the statute. It was Section 708 of Title VII, the anti-preemption section. And it said that only those state laws which purport to require or permit employers to violate Title VII are preempted. Now, as I think Justice Scalia was right to observe, the California law gave employers no such order or authority. That is, if they chose not to treat others similarly situated the same, that was their problem. They could not point to the California law as their mandate or as their excuse. And as Justice Scalia pointed out, if you take that language seriously, that ends the inquiry. It seems to me, therefore, that to say, as I do in Axiom 1, language first, requires that one address what is the right language. And it seems to me that for that one needs a number of background presuppositions. Surely one of them is that in a preemption case, the preemption clause should count for something, especially when it's an anti-preemption clause, and when there is a constitutionally grounded background presupposition of state autonomy unless clearly displaced by an act of the national legislature. So although Judge Easterbrook's demonstration was elegant, I think it was demonstration of the point not genuinely in dispute. And I think the reason has something to do with the unfinished task to which he pointed. And to address that task, let me suggest to you axiom number 2. Interpreting a public law is not the same thing as implementing the private bargains that led to the law's enactment. There's something in the vector model that leads you to draw, I think, too facile an analogy between the court's role in giving content, reasonable import, to the language of an enacted statute, and the court's role in unearthing the complicated bargaining compromise that might have undergirded that statute. Now, I need hardly remind the Federalist Society that a central purpose of the entire Constitution, as reflected by Madison's writings in Federalist 10 and 55, and by Hamilton's writing, for example, in Federalist 78, was to foster civic republicanism, to encourage government action in the public interest, to contain and transcend factions of private and special interest. Now, one inference of that constitutional aspiration, I believe, is that courts should not strain to unearth the private coalitions lying beneath acts of Congress in order to serve as agents for the contending factions and to feel bound by the size and the direction of the precise vectors that entered into the analysis. For example, as it happens, a somewhat unlikely alliance, the Chamber of Commerce and the National Organization for Women, argued in favor of preemption in the California federal case. The Chamber as a spokesman of business interests, and now as a voice opposed to treating women unlike men. Now, let me suppose, for example, although this isn't quite the case, I believe, let me suppose that the legislative history had showed that these same groups had very carefully and successfully lobbied for the pregnancy discrimination amendment's language requiring women to be treated the same, and that specifically in doing so they had hoped to avoid all special rules about how employers should treat pregnant employees. Let me also suppose, to make the case harder, that the section of the statute which Justice Scalia read with some care, the anti-preemption section 708, was not there. I would still be inclined to conclude that unless Congress very clearly displaced laws such as California's, a court should be reluctant to find preemption. And it should be reluctant to find preemption not because we doubt what it means to treat women and men the same, but because California had not mandated treating them differently. And the presumption against preemption with which I would begin is drawn not from an extra-constitutional source, but from what Chief Justice Rehnquist in one dissent some time ago called the tacit postulates of the constitutional plan and the place that that plan gives to state autonomy. That in turn, I think, counsels a clear statement requirement such that if Congress is ever to displace state lawmaking authority, it must do so with a clear statement and not simply with a legislative record that carefully shows that the contending factions wanted to achieve a result that Congress did not, in fact, ultimately enact. Now, I advert here to a general background presupposition of state autonomy. And recognizing the issue of background presuppositions brings me to Axiom 3, and that is that statutory interpretation should not overlook ways in which the very enactment of a law might alter the surrounding legal landscape. This bears on Judge Easterbrook's suggestion about putting a statute down when it does not provide a clear answer. And my thought here requires some explication. Justice Scalia, in a 1978 article on the Vermont Yankee case, observed of the Administrative Procedure Act that it is not self-contained, but rather assumes an entire underlying jurisprudence and practice. The point I want to make is a related but somewhat broader one. It is that all statutes are not quite self-contained. All build on and may reshape the surrounding legal terrain, and they may reshape it apart from what the enactment was meant to accomplish. Now, to make clear what I mean by that, let me turn to an intriguing suggestion contained in several articles that Judge Easterbrook wrote in 1983 and 4. The suggestion was the following meta rule for statutory interpretation, which I think has much to commend it, but with which I see a fundamental problem in some instances. It is this: when a statute neither supplies a clear answer nor clearly delegates answer-giving authority to the courts or to the agencies, as in the Chevron case, then the court should put the statute down and disregard it as though it was never enacted. The trouble with that, quite often, is that the very enactment of a law often changes the relevant legal landscape in a manner that a court cannot legitimately disregard. Several examples, I think, will make the point. In the Douglas Amendment, at issue in the Northeast Bancorp decision in 1985, Congress imposed a federal ban on interstate bank acquisitions. It authorized states to lift that ban. In doing so, it did not focus on whether they could lift it only uniformly for acquisitions from anywhere in the country, or whether they were free to lift it selectively on a geographical basis, regionally, as a number of states have in fact done. Congress did not focus on whether states were left that freedom. Now, how should the Supreme Court have interpreted the freedom that was left to the states? There was one possible background principle available, and that was the principle of no interstate discrimination. Another possible background principle was a principle of state autonomy. In arguing that case for the New England banks, I found it crucial to make one observation, and that is that the very enactment of the Douglas Amendment changed the legal landscape. Congress had itself balkanized interstate commerce in bank acquisitions. Congress, in other words, had destroyed this sphere of interstate commerce. If states chose to exercise their congressionally granted power to lift the ban selectively, they were creating commerce, very much as states, when they enter the market as market participants, create commerce. Because of that circumstance, the very existence of the federal law so changed the landscape that it was no longer appropriate to look at what the states were doing as discrimination against interstate commerce. If they failed to invite more commerce still, they were simply failing to create more commerce than they had chosen to create. Now, in the end, although the Supreme Court upheld these regional laws, it did so in a rather opaque opinion which focused in elaborate detail on legislative history. But I think in the end, what makes the decision soundest is the legal fact that Congress had interposed into the landscape in the form of the Douglas Amendment, not as a window into what Congress meant, not even as an indicium of what reasonable people would think it meant, but as an alteration of the relevant play of forces. Take a second kind of example, the problem of implied causes of action. Now, sometimes the background legal principle should be taken to bar that form of judicial activism, if you will, that involves implying causes of action against the chief executive without a clear statement from Congress. That is what I think makes Nixon versus Fitzgerald entirely defensible. Or take Chappelle v. Wallace in 1983, the refusal to imply a cause of action for a soldier against his military superior. That is, background constitutional principles suggesting that if anyone is to create damages liability in this area, it must be the Congress. But in other contexts, where the background law includes Section 1983, or a body of federal common law, the judicial implication of causes of action should not be taken to involve the illegitimate exercise of attributing to a rump Congress, as Judge Easterbrook aptly describes it, the desire to do more of the same by adding more enforcement to what was provided. It should rather be taken to mean the recognition that the statute passed by Congress against the backdrop of 1983 and relevant areas of federal common law provides a legal basis for liability, which is quite a different thing from inferring a congressional intent to make lawsuits possible that Congress did not affirmatively authorize. A final example I would draw from the Cal Federal decision itself. One particularly disturbing implication of what the court held in Cal Federal from the perspective of the dissenters was that it could produce a result intended neither by Congress in passing the pregnancy discrimination amendments, nor by the California legislature in mandating reinstatement of pregnant employees who develop medical difficulties. That is, the possible implication of what the court held in Cal Federal in some future case might be the existence of a cause of action against covered employers in California who refuse to accord equal treatment to others similarly situated. That is, if a covered employer decides not to provide analogous benefits for a non-pregnant woman or for a male with analogous disabilities, and if someone argues that now violates Title VII, and the employer responds, but California by law made me do it, the rejoinder will be, California didn't make you do it, it only made you give a benefit to pregnant employees. Now, the consequence of that scenario, which much troubled the dissenting justices, was that neither Congress nor the California legislature envisioned such a scenario. True enough. But the two laws taken in tandem so altered the legal landscape that that unintended consequence may be the result of what those two laws do when operating in juxtaposition. And if we genuinely accept the reasonable import model rather than the subjective intent model, that should be taken not as an argument against Justice Scalia's position or that of the majority in CalFed, but as further proof of the most fundamental lesson, and that is that even when a statute does not supply an answer or delegate answer-giving power to courts or to agencies, it's not quite enough just to put the statute down. It would be wrong to put it down without carefully observing how its sheer existence and weight may dent the legal ground on which it is placed. Statutory interpretation, like physics, must not be oblivious to how the objects under observation may bend the very space around them. Thank you very much.
Thank you very much, Professor Try. There was a moment there during your remarks on preemption where I almost thought we could get a Federalist tie around your neck before you leave here. By my count, it looks like three leaning strongly toward reasonable import. We have now coming up as the cleanup hitter, and I can think of nobody better to fill those shoes, a man who has done just about everything, certainly a stellar career in the private sector where he did everything and did it extraordinarily well. He has been in private practice and is regarded among the private bar as a giant in the legal profession, and now on the D.C. Circuit Court where he is continuing to make the same kind of mark for himself, Judge Larry Silberman.
I think I'm right. I only have 5 minutes left. Is that correct? Or how much time do I have? 2. I'll take 7. Actually, I had thought Justice Scalia was going to give one of the points in his talk on legislative history that he did last year, that is to say not before the Federalists, but at other places, in which he pointed out that the committee reports that Congress adopts are invariably written by staffers and that congressmen don't read them, and therefore they should have little impact on judges. I've been thinking about that because it assumed, it seemed to me, when Justice Scalia said that, and he came close to saying that again today, that congressmen and senators read the legislation. And I don't mean that to be in any way slighting, because have you looked at most recent legislation? I dare say that it is more likely that a congressman or senator would read the committee report to try to understand what the legislation was. In any event, that's just an empirical remark, but as I was thinking about it, it occurred to me that where you stand depends on where you sit. A couple of judges on the Court of Appeals here in the District of Columbia were confronting the dilemma recently of trying to interpret a Supreme Court opinion which had a portion of the body of the opinion that said X and a footnote that said Y. And they were absolutely in conflict. And these two judges, trying to puzzle this conflict out, resolved it by concluding the footnotes were written by the clerks. I am going to be very brief, and I'm not going to get into the ground that's been plowed so ably before. I will simply assume we've resolved the degree of legislative history, and we've resolved the dichotomy between what is called the objective and the subjective, and simply make a couple of points. There is one issue of statutory interpretation which seems to me particularly appropriate to consider at the time of our bicentennial. And it seems to me the Constitution suggests something as to a mood or a mode of statutory interpretation which judges often do not accept or think about or brood about. And that is, the Constitution deliberately made the passage of legislation very difficult, perhaps more difficult than is true in any other democracy. So it's simply put, two houses, the president, basically the two-thirds majority to override the president. Basically, it requires a consensus in order to get legislation. And that has certain implications, it seems to me, with respect to statutory interpretation. That consensus, incidentally, is normally, as Senator Hatch pointed out, around a compromise. And there's usually a fault line to that compromise. And assuming we've used the proper method of statutory interpretation to figure out what that is, what are its implications? Well, for one thing, non-legislative expressions of subsequent Congress have to be irrelevant. Absolutely, completely, absolutely irrelevant. Because the non-legislative expression, whether it be a committee report disassociated from legislation, in the air, so to speak, speeches, briefs, etc., are really devices by a subsequent Congress to try to circumvent the constitutional barriers or impediments on legislative action. And therefore, they should be ignored. A fortiori, congressional silence, or as it's used in terms of interpreting the actions of administrative agency, often referred to as acquiescence, also seems to me totally irrelevant. Remember, the founders made it difficult for Congress to act, very difficult. They had to form that consensus. And therefore, for a court, or as I will later say, an administrative agency, to suggest, well, we had that opinion and they didn't reverse us, they didn't do anything about it, therefore there's acquiescence, fundamentally misconceives, in my view, the nature of the constitutional structure. When the court does its job, it seems to me, it enforces the compromise insofar as it's relevant with respect to an issue before the court. It isn't always relevant. But insofar as the fault line is perceived, insofar as the compromise, and by this I mean the compromise between the legislators, not the interest groups, between those legislators who proposed and wished, let us say, to go far, and those who wished maybe not to act at all, or perhaps to act less far than eventually came out. I think in many cases of statutory interpretation, if one thinks about that model, whether putting aside the question of how much legislative history you use, I think it is quite useful and an honest effort on the part of the judges to effectuate that compromise between the legislatures will yield a more objective, a fairer, and a more constitutionally sound method of statutory interpretation. To answer Justice Scalia's question when he said, who is the Congress, after all, contracting with? I think the proper model, and Professor Tribe came very close, I think the proper model is to think of it in terms of a compromise between two, and this doesn't always work, between two segments of the Congress, the proponents and the opponents. And the language of the statute, like a contract, reflects that compromise. Now, quickly on. I just want to briefly make one point with respect to Chevron. I do have time? All right, make 2 points with respect to Chevron. When the judiciary does its job, it seems to me, I've given you the model which I think applies. What happens about it when an administrative agency seeks to interpret the will of Congress? Is it appropriate for the agency to sort of choose up sides between the two wings of this compromise, between the proponents and the opponents, and say, well, we like the policy of that side, and there's enough ambiguity here, we'll run with it beyond the fault line of the compromise? I think, hypothetically, theoretically, that's illegitimate on the part of the agency. Because the agency should do, in that circumstances, no differently, it seems to me, than the courts. Now the question gets more complicated. What about judicial review of that agency action? And here comes Chevron, because Chevron says, for those of you not familiar, which I'm sure is very few, Chevron says, if Congress doesn't have a specific intent on the matter, and the statute is ambiguous, then the court should defer to a reasonable interpretation on the part of the agency. Incidentally, I take that to mean a reasonable interpretation of the statute, not a reasonable result, because some courts take the latter, getting into the subjective policy judgment. But taking it as I've stated it, you defer to the agency's reasonable interpretation if it's ambiguous. But suppose you believe that although Congress didn't have a specific intent on that matter, the particular application here really goes outside the compromise, undermines the compromise. Isn't the agency allowed then to circumvent the fundamental intent of the of the constitutional framers, which is that Congress wasn't going to be able to act but difficultly, and that it was going to be difficult to get legislation? Have we set up a scheme whereby when Congress, whether or not Congress changes politically or not, after the compromise is set forth in legislation, that an administrative agency can take one portion, the losing side of the compromise perhaps, or let's say the slightly majority side of the compromise, and run it further? And doesn't that undermine the constitutional structure? And a question for the government. If the government argues strongly in favor of original meaning, which is original intent, before Justice Scalia gave a speech last year in which he suggested original meaning, wisely that's so. If the government believes very much in original meaning under the Constitution, how then can it justify, as it often seems to do, abandoning original meaning of legislation as subsequent agencies, subsequent personnel and agencies perceive different policies to be desirable that the original Congress did not, and argue for deference to administrative agencies under those circumstances? Aren't they creating an intellectual tension between the underlying justification for original meaning as a constitutional interpretation and a question of statutory interpretation? Thank you.
I'm tempted to open up for questions and answers, but I think if we do, we'll be here for the rest of the evening, and we're on a tight schedule. So those who do have questions, maybe you could come forward and ask them of the panelists as we conclude. I want to remind you all that the reception is at 6:15 and dinner seating is at 6:45 in the ballroom. Thank you again, panelists, Justice Scalia, Judge Silberman, Judge Easterbrook, Professor Tribe. Thank you.